Hi, my name is Shannon Archer with the Polk County Attorney's Office, and today we are going to discuss no contact orders and orders of protection and answer some commonly asked questions about the two types of restraining orders. When I talk about a criminal no contact order, it is an order that is put in place in connection with a criminal charge or offense. And when we're talking about an order of protection, it is a separate avenue through the civil court to obtain protection against another person. We are going to address some common questions about the two types of orders, specifically who qualifies for each of the orders, how long will an order last, how does one cancel or modify the order, and how is the order enforced. So beginning with a criminal no contact order, in this case, there is a criminal charge that is pending where the state of Iowa has come in and alleged that a person referred to as the defendant has committed a crime against a victim. And the victim of that crime may receive a no contact order. Now, what is a victim? A victim is someone who has suffered harm as a result of the defendant committing a public offense. The Iowa law does allow the state to add victims' immediate family members and people who live with the victim on as protected parties. However, generally, the only people that are listed as protected parties are people who suffered direct harm as a result of the crime committed. And this includes children, especially when the children belong to both the victim and the defendant in the criminal case. In that case, generally, only if that child suffered direct harm as a result of the crime will that child be listed as a protected party on a criminal order. They are put in place at the time of when this case starts, which is usually at the initial appearance. And that initial order is in place until the case is over. Once the case is over, the court may extend a no contact order for 5 years after the date of sentencing. Now, a victim does have a right to request an extension of that 5-year no contact order and may do so about within 3 to 6 months from when the no contact order expires. A victim may do that by either contacting the court on his or her own, or the law allows the Polk County Attorney's Office to make a request for the victim to extend the no contact order. Sometimes during the pendency of a case, a victim may request a cancellation or a modification of the no contact order. For example, they ask that they be allowed to have telephone or text message contact with the defendant. In order to have any sort of contact, the order must first be modified. So for example, if a victim wants to talk to a defendant about child schooling, before the victim may have those conversations, the victim must first request a modification of the original no contact order, because remember that criminal no contact order will prohibit or say that a defendant shall not have any contact whatsoever with the victim of the crime. This includes phone contact, text messaging, email, social media. It prohibits a defendant from driving by the victim's house or work or school. So it's important that before any contact occurs, that the court be included in those discussions about modifying a no contact order. And in a criminal case, a victim would request that modification or an outright cancellation of the order from the Polk County Attorney's Office. What happens if a defendant violates a no contact order? Well, the police would get involved and investigate. And if the police officer finds that a defendant willfully violated a no contact order, then the defendant will be arrested, and the court will sentence the defendant after a hearing to jail days. Anywhere from 7 days is a minimum, up to 180 days for each violation that occurs. Comparing this with a civil order of protection, it is different because a civil order of protection doesn't necessarily have any involvement with law enforcement or the criminal justice system. In a civil order of protection situation, a victim of either domestic abuse or of sexual abuse will go down to the historic Polk County Courthouse and fill out what's called a petition for relief of either domestic abuse or sexual abuse. And in that petition, the victim will tell the judge about what type of abuse that he or she has suffered. And the judge will make a determination as to whether a order is necessary to protect the victim. If the court finds that an order is necessary, the court will issue a temporary order of protection and ask that the Polk County Sheriff's Office give the defendant a copy of that. In the meantime, a hearing is set, and at that hearing, the victim will be asked why he or she needs a no contact order, and the defendant will have a right to respond to that request. And if the court finds that there was some sort of domestic abuse or sexual abuse that occurred, and that the order of protection is necessary to protect the victim from any future abuse, then the court will issue that order of protection for 1 year. Once again, similarly to the criminal order, if the court issues this final 1 year no contact order, a victim may, in 9 months or so, request an extension of that 1 year order. And anytime we're dealing with an extension, the court needs to make a further determination that that no contact order or that protective order is still necessary to protect the victim from the defendant. One important distinction between an order of protection in civil court and a criminal no contact order is that in a civil case, the court may address visitation of shared children. So if the victim and the defendant have children together, they may set forth the terms of visitation. The court may decide about shared property, who gets possession of certain vehicles or the marital home, for example, in domestic abuse cases. And so that is one of the reasons why oftentimes a criminal no contact order will not address a child unless that child is a direct victim of a crime, because the civil court is more well equipped to address the needs of the relationship and of the children. If a victim wishes to request a cancellation or a modification of the order of protection, he or she would go to the courthouse, again, where they went to get the original order, and ask for that modification. And as far as enforcement is concerned, a defendant who violates a civil order of protection is responsible for it. Could be held in contempt of court, just like if a defendant violates a criminal no contact order. And once again, that is punishable by a minimum of 7 days in jail and up to 180 days in jail. One important thing to note about enforcing a civil order of protection is that the Polk County Attorney's Office does not get involved because it is a civil case. So usually, if it is the responsibility of the victim, also known as the protected party, to show the court the type of violation that occurred. A victim always has a right to hire his or her own counsel for those, his or her own lawyer, but the Polk County Attorney's Office does not represent victims usually in those matters. So when we look at the differences between criminal no contact orders and civil orders of protection, another thing that they have in common is that they are enforceable anywhere. So if a victim receives one or both of these orders and then moves to Texas, that order is enforceable anywhere within the United States. So taking a look at the map of downtown Des Moines, I want to point out a few buildings for you. This purple building is the Justice Center, and that is where the Polk County Attorney's Office is located. So if someone has a question about a criminal no contact order, that's one place that you can go. I will note that the Polk County Attorney's Office cannot speak to defendants of active criminal cases. So we would encourage a defendant, if he or she has questions about their no contact order, to of course talk to his or her own lawyer. Second, in this yellow block is the criminal courts building, and that's where most of the adult criminal proceedings happen. This is where hearings about no contact orders will happen. And finally, the historic courthouse there in red is where most civil matters are handled. And this is where a victim of sexual abuse or domestic abuse would go to request a civil order of protection. If you have any questions about criminal no contact orders, or if you need referrals for advocates, because advocates are able to go with victims during all of the criminal no contact order hearings and to request a civil order of protection from the court, please give us a call at 515-286-3737 or send us an email. Be happy to answer any questions you might have. Thank you.